Before the short break, I'd taken you to the provisions in the primary legislation. Can I just now take you to the rules themselves?
Yeah.
We see those in the authorities bundle behind tab 4. You have rule 73. You've seen this already, Mr. Laney took you to it. But we see there the definition of domicile date, means the date specified in a collective proceedings order for the purposes of determining whether a person is domiciled in the United Kingdom. So we make 2 points about that. The first point is that it doesn't specify a particular date consistently with the primary legislation. So consistently with the statute, there's not one answer to the question of when the domicile date must be set. And the second point we make really is a response to Mr. Laney's reliance on the present tense is, and we say plainly that refers back to the domicile date, not the collective proceedings order. So domicile date means a date for the purposes of determining whether a person is on that date domiciled in the United Kingdom.
Yeah.
It's as simple as that.
It doesn't tell you what domicile is for either.
It doesn't tell you what it's for.
It just says for the purpose. It assumes there is a purpose and it tells you you fix a date.
My lord, yes, the purpose is discerned from the primary legislation, which if we just go back to that, behind tab 3, we see that what the primary legislation, behind tab 2, and what the so domicile date comes in at subsections, this is section 47B, subsection 11 and 14, a combination of those provisions. And so what we see is that the domicile date is there, it determines who has to opt in and who has to opt out. So persons domiciled in the United Kingdom at the time of the domicile date opt in, and those not domiciled in the United Kingdom at the time of the domicile date, have to opt in, and those who are domiciled in the United Kingdom at the time of the domicile date opt out if they don't want their claims to be included. And that's all that the legislation says. And so really the key point, if one has to identify what is the key issue between our side and my learned friend, it's this, that we say that yes, the domicile date is designed, we can see this, it determines who opts in and who opts out. And we can see from the primary legislation that what it does is establishes a connection with the United Kingdom. But what we do not see, and this is a glaring vacuum in the legislation, is anything which says that the purpose of the domicile date is to ensure that as few people as possible at any particular time, at a specific time, are resident abroad and are automatically included unless they opt out. And that's what my learned friend needs the provision to say. Then if we go back to the rules and Rule 80, this is behind tab 5. So again, we see there quite simply that the Collective Proceedings Order shall, this is the end of paragraph 1, and at G specify the domicile date. So the tribunal has a discretion as to the domicile date it specifies. And we say, of course, that that discretion needs to be exercised in accordance with the governing principles, which you see in behind tab 3 in Rule 4. And those governing principles require the tribunal to ensure that each case is dealt with justly and at proportionate cost, but justly is the key point here. And of course, in exercising its discretion, as with any discretion, the tribunal will of course need to take account of relevant facts in any particular case. Now, the upshot of my learned friend's case, or the implications of her case, and she didn't, to be fair to her, shy away from this, is that when exercising the discretion to set a domicile date, the tribunal has to ignore the individual circumstances of each case and has to not exercise its discretion in accordance with these governing principles. So in a nutshell, we say that whilst the tribunal was correct to find in paragraph 30 of its judgment that the rationale for having a domicile date was to secure a connection with the United Kingdom, and what the domicile date does, its function, is to determine who opts in and who opts out. Its purpose is not the narrower one of avoiding any foreign domiciled person being included in proceedings unless they specifically opt in. And that's important, my lords, because Mastercard needs to identify the statutory purpose which it says the tribunal ignored. And that the statutory purpose they've identified was that they said that the purpose is to avoid any foreign domiciled person being included in the proceedings, brackets, at the date the tribunal takes jurisdiction, which they mean at the CPO date. They say that means at the CPO date, unless that person specifically opts in. And there is just simply nothing in the legislation to support that narrow and specific purpose. On the contrary, the legislation makes it clear that Parliament has not selected a particular date and has not placed strictures on the tribunal's determination of the date. Now, cases like World Development Movement don't really take my learned friend any further, because we of course accept the principle that courts shouldn't act, or public bodies shouldn't act for ulterior purposes. But this is not an ulterior purpose. And if we just pick up World Development Movement just to make the point, it really barely needs making, but the point being that each case depends on the construction of the individual statute. But if we pick up World Development Movement, which is behind tab 11, now, my learned friend relied on bundle page, so bottom right-hand corner, 259, that the power to furnish, that the power in the statute could only be exercised to advance the purposes for which it was conferred. And of course, we accept that as a general proposition of law, but then the question for the court in any case, and the question for this court on this appeal, is, well, what is the statutory purpose? And when you look at the statutory provision in this case, so if you look at page 251 of the bundle, 390 of the report, between E and F, that's where you see the statutory provision. The Secretary of State shall have power for the purpose of promoting the development or maintaining the economy of a country or territory outside the United Kingdom or the welfare of its people, to furnish any person or body with assistance, whether financial, technical, or of any other nature. And of course, what had been found on the facts in that case was that, as a matter of fact, this was not a development which promoted the economy, the development or economy of a country, because it was uneconomic. And so it was entirely unsurprising that the decision of the government, which was essentially a decision to maintain the financial assistance in order not to lose face, was not a decision within the statutory purpose. But pertinently, and if you look at page 263 of the bundled, 402 I think it is of the report, between letters E and G, what the court's saying there is that the Secretary of State is, of course, generally speaking, fully entitled when making decisions to take into account political and economic considerations, such as promotion of regional stability, etc., etc. So it's not that the government couldn't take account of maintaining political goodwill and saving face. It's just they couldn't take account of that if that was their only purpose, because the purpose of this statute was to facilitate was the one that's set out specifically in the statutory provision, which you've seen. So it's an entirely different case, and by contrast with the statutory provision in this case, which, turning back to it, you've got at page 251, the purpose of this provision is not set out in that specific, the purpose of the provision in our case is not set out in that specific way. Now, I'm not going to go to the other authorities, because really my learned friend only relied on them to make good the general proposition that discretions have to be exercised in accordance with a statutory purpose and not an ulterior purpose. And again, that's not a proposition which we dispute at all. The question is, what is the statutory purpose in this case? Now, I'd like to take you next to my learned friend's skeleton argument. So that's in the core bundle behind tab 8, page 61. Because this is with respect where they get into a bit of a pickle, because they say at paragraph 38 of their skeleton argument, so they say, as is clear from paragraph 33 above, Mastercard is not contending for a universal and definitive rule that the domicile date must always be on around the CPO date. And that's because, and so they accept that the tribunal has a discretion. And Mr. Lennon was clear today to say we accept that the tribunal has a discretion. So it's not contending for a universal and definitive rule that the domicile date must always be on or around the CPO date. The first point I make about that is that that submission is inconsistent with Ms. Delaney's submission about what the statutory purpose is. So she has to identify a narrow statutory purpose. The one that she identified was at the date that the tribunal assumes jurisdiction, which she defines at the CPO date. There should be no foreign domiciliaries who are bound by the proceedings unless they specifically opt in. But that is the same as having a definitive rule that the domicile date must be at the same time as the CPO date. So that's exactly the same thing. There is no difference between those two things. So that's the first point we made. Then look at the next sentence of paragraph 38. They say this, they say the CPO date is the correct date in the circumstances of this case, because in this case, backdating the domicile date results in a not insignificant number of foreign domiciliaries being automatically included in the proceedings and so bound by the result. So they're saying no general rule, but in this case, the tribunal acted for an ulterior purpose. But what then is Mastercard saying that the statutory purpose is? Because they have to define it. If they're saying the tribunal has acted for an ulterior purpose, they have to say what the purpose is. It's disavowed saying that the purpose is always to set the domicile date at the CPO date. Its position is that in this case, the tribunal was required to do so because a not insignificant number of foreign domiciliaries would otherwise automatically be included. But that can't be the statutory test. That's far too vague. So what is the statutory test? What this really illuminates in our respectful submission is that this isn't a question about, that there's no error about the statutory purpose at all. Mastercard's real complaint is that the tribunal hasn't given sufficient weight to that factor. But that's not a complaint they can make in this court unless they can show that the tribunal erred on Wednesbury grounds, which they haven't sought to do, quite understandably.
Paragraph 38 is tantamount to saying the exercise of discretion was wrong on the facts.
Yes, exactly, my lord. It's nothing to do with the statutory purpose, and one has to test it like this. So they've said, well, the statutory purpose can't be always to set the domicile date at the date of the CPO, because they recognise they're in trouble if they say that, because that doesn't allow for a discretion. And they recognise there is a discretion. But what is then, what do they say then is the statutory purpose? There is no answer to that question. They haven't provided a satisfactory answer to that question, because the attempt that Ms. Delaney has made to identify statutory purpose is exactly the same as saying that the domicile date has to be fixed on every occasion at the CPO date. Her test is exactly the same as that, because her test is that there should be, at the point that the tribunal asserts jurisdiction, no foreign domiciliary who is bound by the proceedings unless they specifically opt in. It's exactly the same as saying that the domicile date must always be set at the CPO date. There's no difference at all. It's just said in a different way. So really that's the fundamental flaw in their case. And once you get into not insignificant numbers, well then it's all a question of degree. And that really is quintessentially a matter for the facts of each case. And I come back in that context to the point I made at the very outset, which is
600,000, 1 year as a proportion of 5, 1 year and 3.
My lord, yes, and exactly. So in this case, because of Mastercard's appeal today, there has yet not been the process of publicising the claim and having opt-in and opt-out. So if they're right, let's assume for the sake of argument they're right, that the domicile date should be the CPO date. Well, their professed statutory purpose won't be met on their own case. It won't be met because the opt-in and opt-out process won't have happened for at least a year and 3 months after that date. So in that time, there's a good 600,000 people who have left, on their case, left the UK. And we say it's likely to be fewer because not all of those people will have been in the class, but we've gone through that debate already. But as a matter of principle, their professed statutory purpose cannot be met by their submission in this case that the CPO date is the right date.
Because it might be said, if to the extent that Mr. Laney seeks to say, oh no, that's wrong, I'm not saying it has to be, as it mandatorily has to be the CPO date. If it's anything other than the CPO date, then you're left with this sort of impossibly vague concept of the tribunal trying to work out what's the right date to fix on and not in the least significant number of foreign domicilaries.
My lord, exactly. And exactly, that's insufficiently precise to be a statutory test. And once you're in the business of weighing up, looking at different factors, looking at questions of degree, obviously what that tells you is this is a discretionary power where, yes, the tribunal has to take account of relevant factors. Yes, it will be an important factor in each case, how many foreign domicilaries are automatically bound.
Yeah.
But in this case, the tribunal did not misconstrue the statute. It exercised its discretion as it was required to do. And it found, in the circumstances of this case, which are peculiar, because this was one of the first cases, in fact only the second case ever to be issued under the Collective Proceedings regime, only a year after the regime came into force. So it is it is not likely to happen again that anyone will define the class by reference to the domicile date. But that's what happened in this case. And as at the date of the issue of the claim form, 3 million people who have since died had a valid claim. They were within time and they had a valid claim. And it is only because the tribunal made an error in refusing the Collective Proceedings Order at first instance, and this case took 5 years to go up to the Supreme Court and back down again on the remittal. It's only because of that fact, which is no fault of the 3 million people, that those people who had a valid claim that was brought in time are excluded. And that is the factor that weighed most heavily with the tribunal. And we see that from paragraph, if we go back to the tribunal's judgment behind tab 5, paragraph 36, which is on page 45, so tab 5, page 45. They say that this would be a windfall for Mastercard. It would lead to a not insignificant reduction in the size of the claim as put forward in the claim form. And it would result from the original erroneous decision of this tribunal to refuse the CPO and the prolonged process of appeals, neither of which is the fault of those who will thereby be excluded from the class. And that is a factor which is specific to this case, but that, with respect, is precisely what the tribunal should be doing when exercising a discretion. It should be looking at factors specific to the facts of every individual case and taking them into account. And that's what it did. And it placed the weight it did on them, and that decision can't be impugned. Now, of course, that decision is also consistent with the wider objectives of the regime. We've made the point about Le Paturel and your lordship's judgment in that case. And we just emphasise in that context, that's behind tab 15 of the authorities, and I know that you're very familiar with it, but we emphasise paragraph 57, which is on page 393 of the bundle. And yes, this was looking at a different exercise of judgment, the weighing up the various factors relevant to the choice of opt-out or opt-in. But what the Court of Appeal said there is that this weighing up was conducted by an expert specialist body that will over time accrue an increasing well of experience in how to handle these complex cases. the appellate courts recognise that the case management decisions of the CAT are exercises in pragmatism and that undue formalism and precision are not required. And so, by analogy, it's not exactly the same, but by analogy, if we're right on statutory construction, then it's right to say that that the exercise by the tribunal of its discretion is not something that this court should interfere with. But I don't even need to make that submission because they're not saying it should be. So they really place their case under ground one, front and centre on statutory construction. And that's because they realise that it would be very difficult on Wednesbury grounds to interfere with the tribunal's exercise of discretion.
Do you accept that delineation of the statutory purpose is a point of law?
Of course.
Once one gets past that, then the question arises as to whether there's a point of law or not in the exercise of discretion, for which the hurdle is quite high.
My lord, exactly so. And so we of course recognise that interpretation of the statute is a question of law. I've made my submissions on that. I've said why Mastercard's wrong. And then exercise of discretion the hurdle's very high. They haven't, apart from ground two, which I'm going to turn to, where they say the tribunal took account of an irrelevant consideration, they haven't challenged the exercise of discretion. So they haven't raised a Wednesbury challenge. Ground one really is front and centre about statutory construction.
Okay.
And of course you have the point which was emphasised by this court in Le Paturel about the overall purpose of the regime being to vindicate the rights of individuals who couldn't bring claims otherwise. And so when one thinks about that, and then you think about the 3 million people who did have claims at the outset, and through no fault of their own, if Mastercard are right, will have lost those claims, then it's obvious, we say, why the tribunal's right. But we don't need to show that the tribunal exercised its discretion correctly. We need to show that it didn't stray in law. But we do say that it was obviously a correct exercise of discretion. So that's ground one, unless I can assist any further on ground one. There are two more points I wanted to make about ground one, just really to respond to points that my learned friend made. So she placed a lot of emphasis on the limitation point, and I just want to briefly address that. So again, these class members had a claim when the claim form was filed. That claim was not time barred. And what happens is that the CPO certifying the claim allows the claims to continue, but they're claims which were brought in time and which were existing claims.
Yeah.
And it's only because of the 5-year delay that the class members, and the way that the claim form was drafted, but really the 5-year delay, that these class members fell outside the scope of the claim on Mastercard's case. And so we say that this limitation point really is a point in our favour, because it really is tied into the tribunal's finding about the interests of justice.
But it's a non-point, because the claim form was issued in time. It may have only been 5 days within time, but it was in time. And nobody, there was an attempt to shoehorn in people who had already died and who would have to have personal representatives.
Yes.
And the tribunal found against
My lord, that's right.
Mr. Merricks on that point, but on the present point, they're all in time, aren't they?
My lord, exactly right. So they're in time, so it's a non-point. Insofar as it's a point, we say it's a point in our favour because it really reinforces the injustice of adopting the Mastercard position. The other point on which my learned friend placed a lot of weight is really the history of the case and things that we've said about the certification, the domicile date. And she made the point that Mr. Merricks didn't seek to argue that the domicile date should be set at the time of the claim form was issued until later on. Now, obviously the first response to that is that that's totally irrelevant to the question of statutory construction, which is a matter of law for the court. But the second point we make is that one has to look at that in context, and the reason why that argument was not being run was because a bigger argument, if I can put it that way, a more powerful argument, which ultimately failed, as my lords just reminded me, was run, which is that the claim form on its proper construction already encompassed the claims of people that had died, even people that had died before the claim form was issued. And also we had an application to amend in the alternative, and it's only because if those things had succeeded, we wouldn't have needed to worry about the domicile date at all. So it's when those arguments failed that this point really came into sharp focus. But whatever the history of it, that can't affect the proper construction of the statute. So that's what we say about that. Now, turning to ground two, by ground two, Mastercard seeks to attack one of the findings made by the tribunal when it was considering the context of the present case. And we see it, if we can turn back to the judgment, paragraph 32 on page 43. So to put it in context, the tribunal's, the discussion section of the judgment starts on page 41. And at paragraph 25, the tribunal says that the discretion should be exercised having regard to the structure of the regime, the rationale for having a domicile date, the context of the particular case, and the interests of justice.
So which paragraph are you in?
That's paragraph 25, which is on page 41. So that's the structure of the tribunal's analysis.
Sorry.
So page 41 of the bundle, my lord, at behind tab 5.
I was reading paragraph 25 of the skeleton arm, couldn't quite understand why I couldn't.
So now I'm back in the judgment.
Right.
So this is the structure of the approach of the tribunal to the exercise of its discretion. So these are the broad heads that it takes into account, under which it analyses how to exercise its discretion. And these are the four heads, and then it approaches each of these heads in turn. Yeah. And the second ground of appeal relates to a point made in relation to the context of the present case. At paragraph 32, where the tribunal held that it's the clear intention of the claim form, considered as a whole, that they should be included. So persons who were alive on the date that the proceedings were commenced, that's what's said. And my learned friend says, oh, well, that can't be right, because you, Mr. Merricks, were anticipating that the domicile date would be set at the time of the CPO, and at the time you thought that that would be a few months later in 2017. And really, our main response to this ground is to say that it's really difficult to see where it goes, because the key point is that it's perfectly clear that Mr. Merricks did not, when issuing the claim, intend the result contended for by Mastercard. So in other words, he did not intend that persons who had a claim when he issued proceedings, but who died at any point during the subsequent 5 years, would be excluded from the class and would not be, their estates wouldn't be able to pursue their claims. Because apart from anything else, it wasn't, of course, envisaged that it would take 5 years for the claim to be certified.
That sounds as if your response to this point is that the tribunal did make a mistake, but it was only a little one. Is that right?
Well, my lord, I think I have two responses. So one is that really the gravamen of what the tribunal was, the tribunal was faced with a situation where we were saying it should be, the domicile date should be the date of the claim form. And Mastercard was saying it should be the date of the CPO in 2021. Now Mastercard, in a sense, this point didn't come into sharp relief because Mastercard was not arguing as an alternative that the date should be in 2017 when the CPO was made. So that wasn't an argument that they were running. And so the tribunal was deciding as between these options. And what it was saying, if you look at paragraph 33, it was saying, since the class here, you have to ask yourself, well, where does this point go about the intention behind the claim form? It's really going to look at the alternatives that are being posited before it. So since the class here is defined by reference to those living on the domicile date, if the tribunal were to specify that date as being after, and indeed many years after, we would emphasise, the issue of the claim form, then it would have been impossible to determine when the claim form was issued. And that would be inconsistent with the statutory structure addressed above. And when you go back to the section on statutory structure, that makes points about how the regime itself, this is paragraph 26 to 29, how the regime itself envisages that there should be an estimate of the size of the class at the outset. So that's really where this is going. And in my respectful submission, what my learned friends are seeking to do here is really read the decision, the tribunal's judgment as a statute, and really divorced from the context in which what was being argued for by Mastercard was the 2021 date and not the 2017 date. So really the gravamen of the point is that nobody intended that 5 years later that the CPO would be granted 5 years later, and that's really what the tribunal is grappling with, and that's what we see in paragraph 36 of the judgment, where the tribunal explains really the essence of its reasoning on the interests of justice. So in terms of...
If this sentence in paragraph 32 had said, we consider that the clear intention of the claim form considered as a whole is that they or a preponderant part of them should be included.
Yes.
Is that what you're effectively saying? Nobody thought this would be 5 years. The pleading itself recognised the domicile date may take a month or a few months to settle.
My Lord, yes, so I think it's slightly loose language. I have to confront that. So I think it's slightly loose language on the part of the tribunal. But it's not surprising because they were being confronted with an argument that it should be 2021. And they were really focused on... So in a sense, yes, I would read in the words a preponderant part of, or within very short order of the issue of the claim form.
This all goes back to what's said in 31, doesn't it? Which is the point that the context is that the problem arose out of the fact that the class was defined in terms of the domicile date.
Yes.
And what the tribunal's doing here is saying, well, in those circumstances, can it really have been intended, in this case, that the domicile date would be some date other than the date of issue of the claim form? Because if that were so, and that's paragraph 33,
Yes.
A4 or if it's 5 years later, then you'd never be able to, you'd be completely impossible to determine as at the date of the claim form who was in the class. And that's what the tribunal is saying is the mischief, as it were.
Exactly.
And so that's why, on the facts of this case, they're saying that when they talk about the intention of the claim form, what they're really saying is that given that the class is defined by reference to the domicile date, it can't be right that it would not be possible that as at the date of the issue of the claim form to define the class.
Well, that's what.
Because normally, if the class is defined by reference to the date of the claim form, as you would expect,
Yes.
in the usual case, then there wouldn't be a problem at all.
There wouldn't be a problem at all. And what it's saying is, well, if Mastercard were right, given the way that this claim form's been drafted, because as my Lord says, the specific history of the case, the way that the class was defined, if Mastercard were correct, then what you couldn't do is estimate the size of the class, which is what the legislation requires you to do. So, and you look at 26, that's all discussed in 26 onwards. So if you look at 27, for example, the CAT rules require that the claim form includes an estimate of the class size. This would be problematic if the class size could only be ascertained in the future. So what they're saying there, really the mischief, as my Lord puts it, that the tribunal is aiming at, is really to respond to Mastercard's position, which is, well, I mean, you've heard Ms Delaney say today, well, at some point in 2021, Ms Wakefield argued that, or in response to a question put by Mr Justice Roth, said that the domicile date might be in 2021. But what he's responding to Mastercard's position and saying, well, that can't be right, because you would never be in a position to estimate the size of the class, which is what the legislation requires. That could not have been intended.
I mean, it's problematic if you have to do it in the distant future. If you have to do it in the near future, well, it's not that problematic because the numbers might change a bit, but not all that much.
My Lord, yes, I think that's right. But of course, what was being put by Mastercard here was something about the distant future. That's the argument.
That's why we're here.
Exactly, that's why we're here. And that's the argument that that the tribunal was grappling with when it made this finding.
I suppose under the rules as they presently stand, if there's a broad power, the tribunal can, if there is quite a change in the constitution of the class between issuance of the proceedings and the CPO, it could simply backdate the domicile date to the claim, as here.
It could.
If that's a vice it wishes to protect against.
Exactly, because it has a discretion, and so we say that may well be a relevant factor in any particular case, and so it would then have to exercise its discretion and decide whether that is a factor which outweighs other factors. So I think in summary, what we're saying to this ground is that it's really shooting at the wrong target, because the tribunal was concerned with the 5-year argument and Mastercard saying, well, look, you're stuck with this. You've said in the claim form that the domicile date, that the size of the class is defined by reference to the domicile date. That's not going to be set till 2020. There's not going to be certification till 2021. So that's really what the tribunal was directing its mind to. It was saying, well, that wasn't the intention. Of course, it wasn't the intention. And I think that anything else is really seeking really to construe this part of the judgment as a statute and divorced from the context, which was Mastercard's argument that the date should be 2021.
Well, Mastercard haven't run an alternative argument. The tribunal somehow erred in law in picking the claim form date as opposed to the originally envisaged date of February-March 2017.
Well, we were arguing for the claim form date.
It's a,
Yes, I mean, that was, I think, at least the primary argument that we were running, so it was the claim form date. I wasn't at that hearing.
but if the tribunal had said that in paragraph 32, well, it can't have been intended that it should be any later than the anticipated or intended estimated date at the outset, then you couldn't complain about this, or Mastercard couldn't complain about this at all.
No, we couldn't complain, and that may.
If you look at all the documents that were served together, they were all contemplating that the CPO would be made within a very short time scale.
Exactly, and so I think the fair way of reading this part of the judgment, when one takes into account the context and the argument that was being run by Mastercard, and when you look at the link made by, as my lord says, the link made at paragraph 33 between the way that the claim form was drafted, so the link between the definition of the class and the domicile date, and how that plays out when it comes to the rules that you see at 26 through to 29, that the tribunal was really saying, well, look, come on, it wasn't intended that that people that were alive at this time, and I say parenthetically, or shortly thereafter, would no longer have claims simply because the certification didn't take place until 5 years later. That's really what this is getting at. And so that's why we say this ground doesn't go anywhere. Really, if it were necessary, then one has to stand back and say, well, what's the key factor that motivated the tribunal here? And you see that really at paragraph 36, encapsulated in paragraph 36, and its discussion of interests of justice and the 3 million people. And that's simply that's really the essence of the tribunal's decision. And so that's why, for another reason why we say ground 2 doesn't go anywhere for Mastercard. My lords, unless you have anything further, those are my submissions on both grounds.
No, thank you very much, Mr. Dimitri. Thank you.
My lord, listening to my learned friend's submissions, at no point did Mr. Michu identify a principled reason for the domicile date. On her case, there is no statutory purpose. And in particular, there is no case as to when or how it should be set, other than the tribunal looking at the interests of justice. And she is driven to that position because if you logically followed through her case, exactly as Lord Justice Mayles pointed out, my learned friend's case would have to be, it should always be the claim form date, because that brings in everyone with a claim. It's obviously going to be the fairest, it's how it should have been pleaded in the first place, and it would never be the CPO date on her case, because there'd never be a principled reason for that. There was a big debate with my learned judge, the Chancellor, about the jurisdiction, and on her case, it's always the claim form date. Now, my learned friend shied away from that because she knows, and your lordships haven't seen the table, we'll make sure it's added to the bundle, it's not significant, except that in every other case, it's been the CPO date with a gap, sometimes even up to a year or more, between the claim form date of issue and the CPO date. In every other case, 7 cases. And the reason for that, in answer to the Chancellor's point is, yes, we accept jurisdiction occurs over the claim in a sense when it's issued, but jurisdiction over the class and the collective proceedings occurs on the making of a CPO order. That's the regime. And that's why in 2017, Mr. Merrick's counsel recognised that the CPO date was the right date because, as they said in their skeleton, it's when you have an actual claim with a class. Now, if you follow through Ms. Dimitriou's position, her position is that it would never actually be the CPO date. Now, the second point, and I'll come on to her statutory purpose, but the second point, which I think your Lordships have in mind, but really, really does need to come sharply into focus now, is we are only here debating the statutory purpose of the domicile date and having this fight because of the way the claim was pleaded in the claim form and the consequence of the pleading that deceased persons would no longer have a claim from the date of the claim form to the date of domicile. So the limitation point. And it's not a non-point because we wouldn't be here otherwise. Because otherwise you'd never have this debate about the meaning of domicile date because it would actually be very straightforward what it's there for. And the tribunal identified precisely what it was there for, and my learned friends didn't dispute that in their skeleton when we ran with it. So if one looks at paragraph 16 of the judgment and then 29, you'll see that the concept of the domicile date arises in the context of opt-out collective proceedings, paragraph 16, purely for the purpose of determining who in the class has to opt out and who has to opt in. And then if one goes to 29, the domicile date is relevant only for opt-out proceedings for this purpose. It serves no other purpose. And the rationale for the domicile date wasn't challenged by my learned friend in her skeleton either, which is, however vaguely expressed, that it's not appropriate to include automatically those who lack a close connection with the UK, i.e. the territoriality point, which I'm right on because that's the only rationale for this. And the concept of a domicile date was set as the date on which people were living in the UK. We've seen that definition. And so on that date, they would then make the decision to opt in or opt out. That would be when the collective proceedings regime started. And that's the connection for the UK. Now, on my learned friend's case, none of that matters because the domicile date on her case should simply be set to bring in the most people, therefore the date of the claim form, and it doesn't matter about the decision and the mechanics of the opting in, opting out. And it's not we who have a narrow statutory purpose, at least we have one. On her case, there isn't one. And as you know, our case, my lord, starts like this, which is, it can't be on this case, 2016, as the right date, because however my learned friend seeks to rewrite the judgment of the tribunal, the answer is that what they said in paragraph 32, irrespective of use of the word gravamen, the clear intention of the claim form considered as a whole was not what the tribunal found, simply was not. And that's on the face of the documents on a plain and clear reading. Can't get away from that. My learned friend can't get away from that. So once you start from the premise that 2016 isn't even justified on my learned friend's own documents, and it's never been held to be justified in any other case, you're then driven to, on her case, finding the right date to set it at. It simply can't be 2016. She didn't say so. No court has proceeded on that basis, and it doesn't go with the mechanism of the statute where you issue the claim and then you make the CPO order.
I think I understood the respondent's analysis of purpose to be negative. It's to prevent those without any domiciliary connection being able to claim for the reasons set out in 5.56 of the government's response, namely that you could then get a risk of double claims. You could have a claim in the US and a claim here, and you wouldn't be any the wiser until you put in your claim for distribution.
So it's my learned
it's a slightly
friend.
negative way. Other than that, I think it all falls under the discretion of the tribunal.
That's right. And it's my learned friend, therefore, who's got the very narrow statutory purpose, which we say doesn't actually accord with the choice of the name, domicile date, the structure of the proceedings, the consultation, and indeed the tribunal's own findings, which have not been challenged. There's no respondent's notice challenging those passages of the tribunal's decision, which puts it more widely. So what we say is all of my learned friend's submissions, very attractively put, are driven to, it doesn't matter what the statutory purpose is, the tribunal in this case, she says, were right to exercise its discretion.
We're entitled to form our own view, I suppose, about the purpose. We have a smorgasbord of options in front of us, all very attractively advanced. We've got to work out for ourselves what we think the correct purpose is.
Indeed.
And then look at the judgment in the light of our conclusions as the purpose.
But it's important, my lord, to have in mind that before one approaches the concept of the purpose of the domicile date through the lens of 3 million people have been excluded, actually the point shouldn't ever have arisen. And it's only arisen because of the way it was drafted in the claim form. And what the tribunal recognised in paragraph 40 was that the concepts are actually entirely separate and shouldn't be merged. And once you step back and take that approach, which is the real point, you can then see that the domicile date is for administrative purposes in one sense, because it's an opt-in, opt-out date. And in another sense, the concept, the rationale as the tribunal described, is not for this court not to impose proceedings binding people unless they've got a connection to this country. And actually, the domicile date, therefore, has quite a clear-cut, narrow function and is a mechanism within the context of this regime. But it's actually not to be stretched to correct fairness injustices of the type posited here, which arise from drafting and limitation issues. So, my lord, I would just make that point as well, that once you also look at it, and I'm approaching a challenge to this judgment, it's my case, and I would say my clear-cut challenge is to paragraph 32, because however it can be finessed, it's wrong, because that was not the intention. If that was what was informing the justification of the choice of the claim form date, which is, and can I put this differently for my Lord Justice Green? I so far have focused very much on the CPO date being the right date, and that's consistent with every other case. But what is very clear is that the claim form date is the wrong date. And that's because on the regime, there's no justification for that date, the way the statute...
Facts of this case will never ever.
I think never ever, because you have, as it said, the claim form date and the domicile date are different concepts. And you have the domicile date coming after the CPO order has been made. And it wouldn't be logical to be backdated to the claim form date. Here it's arisen because you've got the drafting problem of tying it into people living at the domicile date. But as my own friend herself said, that won't arise in any other case. So that's why it would be a no.
You could have a case where the claim was started, CPO was made 6 months later, and unlike, for example, in cases like Goodman or Le Paterel, where there's unlikely to be much international erosion, there could have been. And the CAT may take the view, for similar reasons, that they want to backdate it to the claim form to bring back in 100,000, 200,000 people. You say that's illegitimate?
Well, my lord, I don't say it's illegitimate, I just don't see a circumstance in which that would arise, because on that scenario, if there'd been a massive erosion, then there would be a consideration still about extraterritorial reach. Those people would have a claim, but they'd have to opt in. So, that's the point I'm making. This isn't about bringing people into the class. People have their claims. The reason this arises, on your lordship's point, all those people their claims aren't being taken away. what's happening.
process them.
Exactly.
But the cat's concern has always been with the practicalities of it. We had this very much in the Petterell about conversion rates from opt-ins to opt-outs. And
That's right.
part of the philosophy underlying is the Act to strip that burden from very small consumers. They don't have to worry about converting it because it's known that they just simply won't, which is a point made by the Supreme Court in Merricks, wasn't it, in this case?
That's right, my lord, in some situations, but it's still 2 points, if I may. The first is that the domicile date isn't the tool for that. There may be other points about opt-in, opt-out, and I think the case you have in mind, that was the point. But the second point here is that the reason we're in this debate isn't because of a practicality issue or a notification issue or a burden issue. It's because the claim form was pleaded with people who've died, and so we're into territory of using the domicile date to make good a drafting problem.
Yeah.
And that's why I'm saying to you that whatever the statutory purpose of domicile date is, and I think it's quite clear from the judgment, and that's the one I'm advancing, hasn't been challenged, the statutory purpose of the domicile date isn't to correct drafting errors. And that's why I said it was a straining the concept. And as I said, the reason you can test that is because no actual statutory purpose has been advanced by the other side that fits their case. And what I was saying to my lord is, I had focused on the CPO date, and I think I'm right to do that, but what I can take off the table is the claim form date, because there really isn't a justification, except drafting errors here. And the tribunal's attempt to justify it is plainly wrong. And so once you take 2016 off the table, and the intention off the table, you're then left setting a date. Now, I accept, and my Lord Justice Mayles posited this morning, and I think my learned friend just agreed with it, that one could have had the 2017 date as a date which was ordered, which was contemplated. That would at least have had a logic to it. But that wasn't what the tribunal did, and it isn't what my learned friend is arguing for. And the reason she's not arguing for it is that she recognises that once you're saying about expectations and intentions, you then get into the territory of the fact that her own side swiftly moved from 2017 to 2021. And that wasn't because Mastercard was taking points about the claim form date or anything else. It was because her own side were trying to advance an amendment, and it hadn't occurred to them to suggest the domicile date would be backdated. They didn't do that. So, my lord, I think it is quite important when one's looking at my challenge to say, well, at least I've got a statutory purpose, and actually the starting point of the other side and the tribunal is wrong. Now, my lord, it was then said, is any connection enough to the UK? Essentially, that's actually the Chancellor's point, which was, I think, gratefully adopted by my learned friend, that perhaps it's enough for the domicile date to not be the date at which people are actually living here, but that the relevant category of people would have had a fair connection to the UK. And my lord, I think, again, that's stretching domicile date simply to meet the facts of this case. Now, if that approach is going to be taken on an exercise of discretion, then at least I understand what the approach would be. But if it's looking at the meaning of domicile date, which is where I'm at the moment, the meaning of domicile date and domicile can't mean any connection years before. It really ought to be, in order to have the function of being the opt-in, opt-out date and meeting the rationale.
But the rationale is you accept, as is stated by the tribunal at 30, not considered appropriate automatically to include people who lacked a close connection with the UK in the UK legal proceedings without a conscious decision of the persons concerned. So that's all to do with opting in and opting out. So what it's saying is that opt-out only applies to those people who, on the domicile date, have a close connection with the UK, and that close connection is domicile in the United Kingdom on the domicile date.
But if one goes into the quotes in 5.56 and 5.57, the Civil Justice Council noted in the explanatory notes of the rules that these provisions are intended to avoid any arguments in relation to national sovereignty which might arise if the provisions purported to assert jurisdiction to decide cases for foreign domiciliaries who have taken no active part in the proceedings. And so you could have somebody who had lived in the UK in the relevant period but lived abroad, but they would be in that italicised passage in the category therein if they weren't currently living in the UK. And that's why UK domiciled claimants is the expression used in bold. So it's obviously a passage the tribunal had recognised as particularly significant. And UK domiciled claimants read naturally means people who are living here now.
Put it into context, consider its practicality. The purpose of the domicile rule is to fix the point at which an attrition inevitably starts. So you fix it at the point of the CPO. The trial goes on and occurs 2 or 3 years later, by which time X number of people had dissipated abroad or died or what have you. So attrition, if you can call it that, is inherent in almost every single solitary case. What domicile does is to, in a sense, fix the start point. It doesn't eradicate attrition, it just regulates it in a pragmatic, practical sense.
Yes, but it does far more than that in my view, because what it does is people at the point of the domicile date make the decision. So you've got the decision at that point to opt in or opt out. Whether or not I then, if I'm a claimant, I make my decision to opt in.
The tribunal makes the decision for you. In most cases, of course, the litigant is utterly oblivious of the existence of the proceedings.
But let's say I have made the decision to opt out and I move abroad, so be it. Let's say I live here, I'm opted in, I choose to move out abroad, but that still means I've got the benefit of it. So the attrition post the order doesn't actually have any significance because you've had the decision. So
It's still attrition, still creates practical problems for distribution later on.
Maybe, but that isn't again what the domicile date's dealing with. The domicile date is dealing with the determining of the class and the opting in and opting out process. And secondly, it's dealing with limiting, and I know my learned friend tries to say it means none, of course it doesn't mean none, but limiting extraterritoriality. So if the attrition happens at the point at which...
But you're accepting it's pragmatic, it's limiting, regulating, controlling.
Well, that's because in
not
every...
eradicating.
I understand that, but in every walk of the court's life, there's going to be some situations where there'll be accusations of extraterritoriality. That doesn't mean that we don't in this country have a principle that it is wrong for reasons of comity to overreach. Doesn't mean there's never an overreach over a single person, but we have a principle, we try and limit overreach because of comity.
Absolutely, understood. That's a fair point. I think probably it only leads to this, that the CAT needs to have in mind the extent of extraterritoriality when it fixes the domicile order as one potentially weighty factor amongst others.
Well, my lord, I would say that seems to be, if one looks at this, the main rationale, the function of opt-in, opt-out, so that you're not binding people who don't live here automatically. And if you live here at the time and move abroad, well, the point at which the order was made, you were a domestic citizen. So the attrition point, in my respectful submission, doesn't matter because as at the point in time, you were living here if you were bound automatically.
You made a point a little while ago, perhaps not your main point, that the tribunal had emboldened paragraph 557. Is it actually the tribunal's emboldening or is it the government's?
I don't know the answer to that. Can I take instructions on that and come back to you? I had made an assumption, and you're right to say possibly a wrong one. My learned junior will no doubt
No, that's fine. Thank you.
produce the answer. So, my lord, what I would say is it's not a connection to the UK more generally. It's a connection to the UK for the purpose of opting in, opting out. And if you follow that through, why do you need the opt-in, opt-out? And it's because those living here are within this court's jurisdiction and therefore automatically bound. Whereas people who aren't living here at the time of the order, we would say, and that's a logical point, should have to opt in themselves. And that's what we say is logical. Now, I'm not saying, and I'll have to meet the next point, that that has to always be the case. But what isn't right, and on my learned friend's case, if it was something different, then it would always be the claim form date.
The bold, the original.
In the governance. So the bold, my lord, you're absolutely right, is in the original. It's in the governance.
Thank you very much.
My lord, the next point is that it's said against me that we haven't really engaged with the movement point. I think, and why can we be so sure that lots of people have moved and so on and so forth, in the sense of those people being prejudiced who would have had claims opted in, and then they moved abroad, and now because of the timing of the order haven't. And the only
Or we just assume the numbers are substantial, whether it's 3 million or whatever. I mean,
well, I think it's 3 million people have died, and it's in footnote 5 to our skeleton. We give the figure of people moving generally within.
it's from the House of Commons. This was the
That's
House of
right.
Commons.
And it's 2 million people during the relevant period.
We're probably going to assume it's significant or substantial.
That's right.
Whatever the exact figure.
That's right.
It's a material figure. for
It's a
purpose of
material figure.
analysis.
So the timing of this order has consequences both ways, and you can't assume, my lord, with respect, that the 3 million died figure trumps the impact on the other group of consumers. So when one's considering what's in the interests of fairness and the impact on groups of consumers, and as your lordship said, many won't know about it if they live abroad, you can't assume that this order made by the Troop Tribunal is the fairest. And so that's a factor when you come to consider the interests of justice. And I think, my lord, my final point, because I'm otherwise trammelling over continued ground, is really that my Lord Justice Flo put to me that the tribunal had well in mind the statutory purpose. And it's right to say the tribunal cited the statutory purpose and set out the legislation. But with all respect, and there's no other way of putting this, paragraphs 38 to 39 simply are an attempt at reverse engineering.
Sorry, what?
Paragraphs 38 and 39 of the judgment, as revealed by paragraph 40 in my respectful submission, are just reverse engineering. The tribunal did not start with the simple question of when do we set the domicile date. The tribunal started, as is revealed by the judgment, paragraph 6 onwards, with the problem that if they set the domicile date at the CPO date, there would be 3 million people excluded, and that you couldn't get round it any other way because of the drafting of the claim form and the recognition of the limitation consequences of that. And so the only way to get round the problem, in their view, was the domicile date. And they took the view that because of their discretion, they could set the domicile date in the interests of justice. And we say that's reverse engineering because they recognised in paragraph 40 that the domicile date had a particular statutory purpose which they had gone beyond, and they set out that statutory purpose, but instead of exercising the domicile date with purely restricted and limited, as they say, to the statutory purpose, they allowed the particular factors of this case to pervert the statutory purpose and to set another date. And even if I'm wrong on the CPO date, the tribunal's decision of the claim form date simply doesn't withstand scrutiny. And so, my lord, and once you unravel that, you then do have to think about why you would pick the date they expected the tribunal might make a decision, because it's that uncertain. And if you're going to say, pick the date they expected, then you do have to look at all the other factors later on. So, my lords, unless I can assist you any further.
No, thank you very surprised to hear we will reserve our judgment. Thank you all on both sides, counsel and those behind them, for all the assistance we've had. Extremely interesting, albeit, as I said at the beginning, a relatively short point. You'll get the judgment in draft in the usual way for typographical errors to be identified, not for pleas for re-arguing the case in any way. And I simply draw attention in advance to the terms of the embargo that will be imposed on the judgment as to who has access to it and what they can do with it, which I trust all counsel are now extremely familiar with, and ensure that anybody on their team is also extremely familiar with. Thank you very much indeed.
All rise.